Hello, I'm Tom Cross and welcome to Cross-Examination. I'm a barrister in London working on cases with cultural, moral and ethical importance. In this podcast, expert panellists join me to take an independent look at the law surrounding one of these issues. In the early hours of the 13th of July 2003, a woman was stalked, brutally attacked and raped by a stranger. She gave a description of her attacker to the police, who later accused Andrew Malkinson. The Crown Prosecution Service decided to prosecute Malkinson, and he was convicted of rape by a 10-2 majority of the jury. The decision depended on witness identification evidence. Malkinson's DNA could not be found on the victim or at the scene. Throughout his term in jail, Malkinson protested his innocence, which extended the amount of time he spent in jail, a total of 17 years. But this year, 2023, the Court of Appeal decided that Malkinson should not have been convicted, both because of evidence showing the DNA of a different man on the victim, and because the prosecution hadn't disclosed at trial evidence undermining the credibility of the identification evidence on which he was convicted. Now a free man, Malkinson seeks compensation. But are the failings which led to Malkinson's wrongful conviction problems with the system, or the operation of the system, or both? Where are the weak spots in our criminal justice system which may make wrongful convictions more likely? And should anything be done to change them? Cross-examining with me today are two criminal barristers whose work goes to the heart of the issues. Max Hardy was junior counsel in Andrew Malkinson's appeal, having worked on the case since 2020. He's a former chair of the Young Barristers Committee of the Bar Council, a trustee of the legal education charity the Kalischer Trust, and helps the organisation Amicus train prospective interns to work on death penalty cases in America. Joanna Hardy-Suskind is a criminal barrister at Red Lion Chambers who specialises in defending allegations of homicide and serious sexual offending. She's an experienced appellate lawyer and is described by the Legal 500 as an absolute star. She's not married to Max Hardy, despite everybody thinking that they are. Welcome to you both. Joanna, let me start with you. I want to explore some of the basic features of the system which may be relevant to miscarriages. In the period before a trial, and indeed before somebody is prosecuted, work needs to be done by two separate bodies, doesn't it? The police on the one hand, and a body called the Crown Prosecution Service on the other. What are the respective roles of those two different bodies?
You're quite right, Tom. So if a person is accused of a crime, the first thing that will ordinarily happen is some kind of police investigation. That will depend on the nature of the allegation. If it's fighting in the street, if it's a punch-up, the police might look for eyewitnesses, CCTV, medical evidence as to any injury. If it's a fraud, they might look at electronic evidence. They might look through your emails or your phone. Police should investigate lines of inquiry that lead both towards guilt of an alleged suspect, but also away from it. And that direction of the investigation, the sort of complexion of the investigation, is very important if a case does reach trial. Quite often I will cross-examine an officer. What about the chap in the red hat? Did you ask him any questions? What about that blue car that sped away? Did you look up the number plate? As part of the investigation, every single item, every witness, every single piece of footage or electronic data has to be scheduled somewhere. Someone needs to write it down and keep a list. Some of that stuff will become evidence. It's what Max and I call used material. Some of it will not form part of the prosecution case, becomes what we call unused material. But the crucial aspect is that anything found in the course of the investigation is logged. It has to live in a bucket somewhere. It can't live in the back pocket of the police officer or in a drawer somewhere. And that's so the disclosure process can happen.
So we're going to come on to the disclosure process. You've spoken about the functions of the police. What about the Crown Prosecution Service? What do they do?
So if a case is to progress, the file is often passed to the Crown Prosecution Service to consider a charging decision. They can either charge a suspect, refuse to charge somebody, or ask the police for more information. The test they use is whether there's a realistic prospect of conviction and whether prosecuting that particular person is in the public interest.
Not the only type, but one type of miscarriage case that emerges is where there was an issue over the identity of the person who was accused of committing the crime, a whodunit case. And where you have a whodunit case, so where the defendant is denying that it was them, but there's a decision to prosecute them, the evidence needs to establish it was them, and that evidence can take different forms. Physical evidence in the form of, for example, DNA evidence, which might place a defendant at the scene of the crime. But you also might have and might need to rely, Joanna, on eyewitness evidence. Now, there can be difficulties with both of those, the Barry George miscarriage, for example, in relation to DNA. Is it fair to say that a greater difficulty can also arise with human eyewitness evidence?
Yes, so ID evidence as a concept is notoriously tricky. It's tricky for barristers at court. And in fact, jurors in trials are given special directions by the judge about the limits and risks of ID evidence because experience has taught us and still teaches us that human beings are fallible. If a circus paraded through this room now, you, Max, and I would remember things differently. I might swear blind that the elephant was pink, and Max might think the elephant was orange. None of us would be trying to lie, trying to deceive, trying to cause trouble, but some of us would be wrong. And that obviously applies in the criminal courts and when eyewitnesses experience and see crimes.
One form of identification evidence that's used is that which is taken from a so-called ID parade. What is an ID parade, and are there special rules in the courts which urge caution in relation to evidence gathered by that means?
So an ID parade, Tom, is where a witness has seen a suspect and has indicated they think they might be able to identify them again. And the police will organise people of a similar physical description to literally do a lineup. And when members of the public watch TV shows and see the ID parade lineup, those do happen. Now, they're not all lining up in one room like on TV. They're often done on a video now. And what's important is the quality of that first sighting. So you'll appreciate that if I glance somebody across a dark nightclub dance floor after a few pina coladas, that's very different to spending time looking at a suspect who might have knocked on my door and tried to defraud me, and I've spent 10 minutes looking at his or her face.
And we increasingly see in cases now with CCTV that you can watch footage of an incident and then compare that to eyewitness testimony, and you actually get real life experience and examples of how wildly inaccurate eyewitnesses can be.
Experience teaches us that people can pick out the wrong person, they can pick out nobody at all, but it doesn't mean they're not doing their best. And there's a difference between a malicious witness and a honest but mistaken witness. And so, yes, there are strict rules around how the parade is conducted, how the parade is treated at trial, and directions for a jury about the caution they must apply to cases that turn on ID evidence.
Explain to us a bit more about disclosure. What is it? What are the duties on the prosecution and the defence?
This is at the absolute heart of our criminal justice process, and it's really important that it's explained that there is no automatic entitlement of a defendant in England and Wales to see anything and everything in the hands of the prosecution. In other jurisdictions, there is that sort of entitlement. As Joanna has explained, the police and the Crown Prosecution Service are under a legal duty to schedule the relevant material in their hands. That material which forms the evidence in the case gets served, as Joanna says, as used material. The police are supposed to draw to the attention of the Crown Prosecution Service any material in their possession which in their view may assist the defence case or undermine the prosecution case. And then the Crown Prosecution Service, over and above that, are supposed to conduct their own review of the unused material. And disclosure simply means handing over to the defence anything in the possession of the prosecution which might assist the defence at trial or undermine the prosecution case. Almost all miscarriages of justice have at their heart a failing of a disclosure process.
So you shouldn't have, in theory, to ask as the defence for a piece of evidence that would undermine the prosecution case. They ought to give it to you automatically, is that right?
They should, and they're supposed to be considering their disclosure obligations right from the beginning of the case, really before the case is even charged. And in most cases, some disclosure gets made from the outset. Now, of course, if the prosecution don't know what the defence case is, if there's a no-comment interview and absolutely no indication at all has been given of what's an issue in the case, it can be quite difficult for the police and the CPS to know what material in their hands might assist the defence. And that puts the onus on the defence to state their case. And in Crown Court proceedings, those are obligatory. And when that is served on the CPS, that's sent to the police, there is then supposed to be a review of all of the unused material and any further disclosure arising. But it's not a one-step process. The disclosure obligations exist all the way through to trial, and also, and critically importantly in Andrew Malkinson's case, beyond trial as well.
Let me wind forward then to the verdicts. In our country, in jury cases, so for the most serious offences, we have only two types of verdicts, leaving aside special verdicts. You're either guilty or you're not guilty. We don't have, in England and Wales at least, a third type of verdict, Joanna, like not proven.
It's one or the other, or they can't reach a verdict, which takes some explaining. Max has heard me say this to a jury or two. It means if a juror steps back and considers the evidence in the round and thinks a defendant might have done it, maybe did it, possibly did it, or even if they think, do you know what, I think he or she probably did that, that's not enough for our system. Probably guilty is not enough. And it means if you leave a trial thinking that defendant probably committed that crime, they are in law, in fact, not guilty.
One effect of that dual verdict system is that if you are not guilty, it is ambiguous. It's unclear whether the jury is of the view that you positively didn't do it, or simply the prosecution haven't proved their case to the required standard.
Yes, and as a defence barrister, you tactically need to make a choice. It's not one that I haven't taken, but it's a bold move to make your job harder than it needs to be and say to the jury, look, not only have they not proven this case, I can point to A, B and C that shows that this person is demonstrably innocent. Those are rare cases because obviously a case has had to get past a charging decision, any application to dismiss or half-time submission that there's no case to answer. So if you're addressing the jury at the end of a trial, it's rare that you would make your job more difficult than it needs to be.
There are 12 people on a jury, but not all of them have to decide that you're guilty if they're going to convict you necessarily.
No, we have majority verdicts in this country. So when a jury of 12 retire, this is working on the basis that one of them hasn't got unwell or gone on holiday, the judge will say, I need a verdict upon which you all agree, a unanimous verdict. But if they're in retirement for an appropriate period of time, there will come a time where a judge will bring them back into court and say, please still strive to agree, but I could now take a verdict upon which at least 10 of you agree.
You can appeal against a conviction if it's what's called unsafe.
Ordinarily, what would happen is the counsel who had represented you at first instance would advise whether you have any arguable grounds of appeal against conviction. Those might be misdirections of law by the judge, might be a decision during the trial that's considered to be have exercised wrongly, and if counsel thinks it's arguable, they can draft an advice and grounds of appeal. Those would be considered by Gatekeeper 1, a single judge in the Court of Appeal. If granted leave, or if you choose to press on without leave, it would then be determined by the Court of Appeal at a hearing. It's not good enough to show that there was just an error or something went wrong. It has to be causative. It has to have rendered that conviction to be unsafe. And so even if you manage those high hurdles, it's rare to persuade the Court of Appeal that a conviction ought to be overturned.
Now, whatever the system, miscarriage of justice can in theory occur. That there's a body in this country, isn't there, called the Criminal Cases Review Commission. That's going to be a central player in what I want to come on and talk about later. What is the CCRC? And what's its function?
So the CCRC, the Criminal Cases Review Commission, is essentially a safety net. They have the power to refer a case for appeal even after the initial appeal that I've just set out fails. They're independent of the police and the courts, and their test is whether they consider that there is a real possibility that the Court of Appeal will quash the conviction or reduce the sentence, depending on what you're appealing. Just because you can get your case referred by the CCRC doesn't mean you've won your appeal. It just simply places you back in the arena of the appeal. Of course, the Court of Appeal can grant or refuse it thereafter. And so in theory, it's an excellent body and a crucial service, and it's a last resort for many people. But in practice, we've seen and heard of difficulties, and I think we'll hear more about those in due course.
Let's come on to the Andy Malkinson case then and start by identifying what the key features of that case were that led to a miscarriage being established. First of all, the case against him depended entirely, as I understand it, on ID evidence. The victim herself misidentified Malkinson to start with.
That's right, and it absolutely exemplifies how dangerous that type of evidence can be. And of course, one has to acknowledge she did identify Andrew Malkinson in very far from ideal circumstances. This was obviously a horrific attack that she experienced. It culminated in her losing consciousness. She had consumed some alcohol earlier in the evening, and it was the kind of identification which on its own, without any other identification evidence, would have been seriously susceptible to being excluded by a judge on the basis that the circumstances of the observation were so disadvantageous. Her identification evidence was bolstered by that of two apparent independent eyewitnesses who, on a prosecution case, just happened to be driving by in the middle of the night in company. In this case, there were very serious grounds for doubting the honesty of these two witnesses, but all of that was hidden from the defence by way of the non-disclosure.
Well, Malkinson, of course, was much later to be exonerated. I spoke to James Burley, the investigator at the charity Appeal, whose work achieved his exoneration, about what Appeal does, what went wrong in Malkinson's case, and what he believes are serious failings with the system.
So I'm James Burley, and I'm an investigator at Appeal. So Appeal is a law practice and charity which investigates and litigates miscarriage of justice cases. We not only try and achieve justice in individual cases, but use those cases to drive systemic change in the criminal justice system. We receive very little legal aid funding for our work, so we're mainly dependent on grant makers and also some support from corporate law firms. Because of the lack of legal aid funding, there are very few lawyers doing this kind of work in England and Wales. The sort of work that Appeal does tries to fill a really significant gap in legal representation. The big problem with Andy's trial was that he was deprived of evidence which undermined that identification evidence which formed the entire prosecution case. The victim was walking home in the early hours of the 19th of July 2003 in Greater Manchester, and she was essentially stalked and brutally attacked and raped by a stranger, near enough left for dead. Police obviously began an investigation. She gave a description. Remarkably, even though he didn't fit the description, Andy became the police's prime suspect, and they ignored other leads, and the result was the wrongful prosecution and conviction of Andy Malkinson. So the prosecution case was entirely dependent on identification evidence, which we know is so fraught with risk. So there was no CCTV which implicated Andy, no forensics. He didn't have any bad characters to suggest that he'd be capable of something like this. So it was a case that was entirely dependent on ID evidence from the victim herself and two identification witnesses who were presented at trial. The female witness, Beverly Craig, she actually didn't pick out Andy during the ID procedure. She picked out somebody at a different position. Supposedly, as she was being escorted out the police station, told a police officer that actually she got it wrong and she meant to pick the number that Andy was at. Her partner did pick out Andy during an ID procedure, but it didn't take place until 6 months after those original sightings, which lasted mere seconds, were made while he was driving. The jury were very much given the impression that these were honest witnesses, and actually what emerged was that these were people with track records for dishonesty. The previous convictions of those two witnesses had been withheld, and the defence had specifically asked for those previous convictions and not been given anything back. The other really crucial bit of evidence that was not disclosed to the defence was some photographs which showed the victim's hands. The victim was adamant that she had scratched her attacker's face and broken a nail in the process, and she said that she'd used her left hand to do it. And Andy didn't have a scratch when he was seen by police the next day. So that was the strongest defence point. But some medical evidence was called by the prosecution, which said that actually the victim had got the hand on which she'd broken a nail wrong. And that was used in the judge's summing up to cast some doubt over whether she had really scratched her attacker at all. Because these photographs weren't disclosed, the defence were unaware that that medical evidence was actually wrong on that point. 2 of the 12 jurors who heard the evidence were unconvinced of Andy's guilt. But in this country, unlike in the US now, a majority is all you need to convict. A 10-2 verdict sent Andy down for life. In 2006, Andy's appeal was rejected, and that appeal really centred around some issues to do with contamination and some forensic results. The non-disclosure of really crucial photographs that showed the victim's hands and the previous convictions of those central prosecution witnesses had not yet come to light. So the court was not aware of that information when it rejected Andy's appeal. In 2007, there'd been a key breakthrough in Andy's case. So some DNA testing had been done as part of a nationwide retesting initiative called Operation Cube. And what that found was that there was male DNA on an area of the victim's vest top. And that DNA could not have come from Andy. It couldn't have come from her partner. And various other sources have been ruled out as well. The next step was that Andy in 2009 applied to the Criminal Cases Review Commission. That's the public body which was set up in the wake of the Birmingham 6 and Guildford 4 cases and other cases with the aim of sending back miscarriage of justice cases to the Court of Appeal. That body really should have been Andy's saviour. but it ended up being a barrier to justice. Andy asked them to conduct a full forensic review of the case. They declined to do any new DNA testing. They essentially tried to explain away the presence of that non-matching DNA by saying, well, it could have come from the attacker, but equally it could have come from some innocent source. The other thing was that the CCRC didn't bother to do any investigation, and as a result, they didn't uncover any of the non-disclosure, which we later uncovered. So we first heard about Andy's case, I think, back in 2016, and so we set about trying to arrange that forensic testing ourselves. We also took the police to court twice to obtain the undisclosed material. So there's a piece of case law that governs post-conviction disclosure, is a case called Nunn, and it sets an incredibly high threshold that you need to meet in order to access disclosure post-conviction. Initially, our request was refused in full. We decided to initiate judicial review proceedings, and when we did that, the Greater Manchester Police decided to actually comply and allow me to go up there and look through the boxes of material, make copies of everything. And it was through that process that we first discovered the photographs and also the first signs that there was something more to these two key prosecution witnesses. One of the things that became clear once we instructed an expert was that the police couldn't find certain key exhibits in the case. They couldn't find items of the victim's clothing. That could have potentially been disastrous for Andy and meant that no testing could have been done. But fortunately, samples that had been taken from those items of clothing had been stored separately by a body called the Forensic Archive. And that meant that we were able to commission testing. We presented all of this information to the CCRC, and they finally decided to refer the case. They did a search of the National DNA Database for the partial profile that was present on the vest top, and they got a hit. That was in late 2022, and that individual has since been arrested. The really shocking thing is that that individual's profile was uploaded to the database in 2012, just after the CCRC first rejected Andy's case. If the CCRC had simply searched the DNA, which was already known about, and they'd arranged periodic searching of the database, that individual could have been identified a lot sooner. The Court of Appeal allowed Andy's appeal on 3 grounds. So firstly, the new DNA evidence, which implicated another man, and then on 2 other grounds, which were to do with the material non-disclosure that I described earlier. Essentially, they agreed that the material that had been withheld wrongfully from Andy's defence at trial could have changed the jury's mind. So Greater Manchester Police got this wrong right off the bat. Their investigation got tunnel vision. They focused purely on Andy and ignored other suspects. They unlawfully withheld key evidence from Andy's defence. And on top of that, once Andy was convicted and began his efforts to overturn his conviction, they unlawfully destroyed evidence on 3 separate occasions, really crucial exhibits that Andy wanted DNA tested. This miscarriage of justice wasn't some sort of accident. It was a totally preventable disaster, which resulted from the fact that essentially the prosecution, the police cheated at trial. They withheld evidence that would have undermined their case. So I am very firmly of the view that Andy's wrongful conviction was not some aberration of a system that is otherwise working very well and is fundamentally sound. I think it's exactly the opposite. It was an inevitable consequence of a system that places way too much power and trust in the police. Essentially, the police are entrusted to be fair gatekeepers to the material they hold and to pass on anything that could assist the defence case or undermine the prosecution case, firstly to the CPS, and then the idea is that the CPS then pass it on to the defence. I find it remarkably naive that in an adversarial system, we entrust one side who are motivated to get a conviction to act as this kind of faithful gatekeeper to the evidence. And once the police think they have their man, they will look for anything to support that, and they will, in some cases, hide anything that undermines it. The other problem is that there's no real tradition of defence investigation in this country, unlike in the United States, where at public defender offices you have in-house investigators. There are many things fundamentally wrong with the CCRC. This wasn't just one case that they dropped the ball on. The wrongful conviction of another man called Victor Nealon was overturned. The similarities between Mr. Nealon's case and Andy's case are really striking. And the CCRC did not learn from Victor Nealon's case at all. And that's why I say that it's not some sort of isolated case. And then one other point, I think, is the CCRC's sort of chronic failure to carry out investigation on cases. It really does approach cases in a very kind of close-minded way. I think maybe one thing that needs to be looked at is introducing a legal duty which forces the CCRC to pursue all lines of inquiry. The CCRC has all these incredible statutory powers that allows it to obtain material from the police, from MI6, whoever, if they want to. They don't use them enough. And Andy's case was a really good example of that. Of course, the CCRC needs to be properly funded, but that is really not the fundamental issue here. And I'm convinced that if you gave it some more money but didn't address any of the systemic problems with the way the CCRC operates, you'd see very little difference. The day that Andy's conviction was quashed was a hugely satisfying moment. Seeing Andy speaking outside on the steps of the Court of Appeal to all of the media who'd assembled and how he spoke so powerfully. I think, though, that it was tempered with the fact that, it should not have taken this long. It took 20 years, but it obviously took a huge amount of work for a small organisation like ours to get that disclosure, and it's something that would be totally inaccessible to most wrongly convicted people currently in prison. I know that there are many others in his situation who are still struggling to get justice, so there needs to be a complete overhaul of the CCRC for it to become an effective, accountable body.
Well, Max, Joanna, I want to consider how far you think the criticisms made by James Burley there have force. First of all, on the non-disclosure at trial of material in the state's possession. Now, we've explained the disclosure duty on the prosecution. That just didn't happen properly in his case.
There were all sorts of reasons to have anxiety about the reliability of their evidence, and that's even before one comes on to the non-disclosure points. Both of them said that they saw a man following a lone female. So neither of them said they were actually witnesses to the attack itself, but more the moments building up to it. And then they said that they were driving back in the other direction. And so they were claiming that there were two observations of the man who was acknowledged at trial by the defence as almost certainly the attacker. Both of those observations were extremely short in duration. They were made from a moving vehicle. And Joanna's referenced what gets called in the courts as an honest but mistaken witness. And they are very, very dangerous and difficult witnesses for the defence, because obviously somebody who is honestly doing their best can sound extremely persuasive. And when one is confronted with identification evidence, the starting point is that the witness is honest but mistaken. If you're defending, you're saying your client wasn't there.
They hadn't disclosed the fact specifically that they had previous convictions, including, I think, for deception.
Precisely. And so when you are defending in a case like this and you're handling witnesses like that, the way that you would approach them is dramatically different if you're being told these are civic-minded, public-spirited members of the public offering themselves up as identification witnesses, in contrast to these are two people with previous convictions for dishonesty, and the sort of history that's going to give any proper defence barrister and solicitor serious pause for thought, and also, importantly, triggers further inquiry. So as Joanna has already alluded to, when a defendant is being properly defended, when you're given information and that information raises questions, you pose those questions, you pursue the matter, and the way that you strategically approach a case differs dramatically depending on the information that's made known to you.
Just to be clear, Max, these previous convictions for dishonesty of the key identification witnesses for the prosecution, those previous convictions aren't something that the defence ought to have had to ask for. They're something which automatically should have been provided by the prosecution.
I would absolutely say that. As it happens in the Malkinson case, there was an explicit request for the previous convictions of all prosecution witnesses, and that is an absolutely standard disclosure inquiry made in almost all defence case statements. And what's so troubling about the Malkinson case is that did trigger disclosure of previous convictions of some prosecution witnesses of very peripheral significance in light of the case at trial, but not of these two identification witnesses who were at the absolute heart of the prosecution case. And the other thing that's so concerning about their conviction history is that not only were the previous convictions not disclosed, the fact that they even had any was obscured. So we've referred to these schedules of unused material. There was no reference anywhere in the schedules to the fact that these two witnesses had conviction histories.
Was the fault, in your view, simply operational here, people not doing their jobs properly? Or does there need to be a change to the disclosure rules?
In my view, this is largely an operational concern in the sense of that material was withheld, and I regret to say my perception is withheld deliberately. And of course, when material is being concealed, it doesn't matter what disclosure regime you've got in place. It doesn't matter what the rules require. If people want to hide significant evidence, it will be hidden. And so I wouldn't say on that particular score that Malkinson justifies a wholesale revision of a disclosure regime.
Joanna, from your experience, is disclosure plain sailing? I wonder whether you have any sense of being troubled, perhaps as a result of resources pressures on the prosecution as to whether or not they're doing their job properly.
It's not always plain sailing, I'm afraid. And often we have what I call a near miss. I finished a trial recently where I was served with a document during the trial, which in my view was a game changer. And that defendant went on to be acquitted. And had that document not emerged, I wonder what would have happened. Often at the end of a trial, prosecution and defence counsel almost breathe a sigh of relief and think, well, thank goodness we discovered that. I never think, and I have never thought, that those failings are deliberate or that they are malicious. I have always thought they're down to human error or human beings, officers and people working at the Crown Prosecution Service who are overstretched and who are being asked to perform a task with too few resources too quickly. I think the test is good. I think the system is good. I think the scheduling is good. I think that the pressure on the human beings involved in the system falls short. But I'm afraid that's no comfort to my clients. So I have little patience with it because the government should be funding the system properly.
What about this point that James Burley makes that's related, it seems to me, to disclosure about the lack of tradition that there is in this country of a defence investigation for the defence to go off itself and gather material that may help to exonerate a defendant? It's a question rather for the defence of seeing what the prosecution has in terms of the evidence against the defendant and requiring them to prove their case. Is that right in practice?
It's right and it's wrong in practice. I think it depends on the case, depends on the nature of disclosure and the relative strengths and weaknesses of each side of the courtroom. And Max has prosecuted me and will probably tell you that I become a bit of an investigator because when I write a defence statement, I probe and ask every question I possibly can. And I imagine I'm quite an awkward opponent to deal with for the Crown Prosecution Service and for the officer in the case. The sort of traditional concept of an investigation rests with the police in this country. But you're quite right, we don't have what they have in the American system of habitually hiring an investigator to sort of do a defence police officer's job. It's a different culture. We don't go around investigating things and hiding in alleyways and jumping out at witnesses. But it doesn't mean the defence side of the courtroom can't fight back and cause a little bit of trouble.
Max, we know that the CCRC didn't refer Andy Malkinson's case on a couple of occasions before it, on a third occasion, ultimately did. Leaving Andy Malkinson's case aside, there's a criticism quite often heard about the nature of the test that the CCRC apply. In other words, whether they think there's a real possibility that the Court of Appeal will overturn the conviction as unsafe. And the concern is, broadly as I understand it, that this leads to them being overly cautious in not being willing to refer cases. In your experience, is that a problem? Is there a difficulty with the nature of the test? If so, should that be changed?
My personal anxiety is not around the test because I think you can get lost in semantics very easily. My concern is people knowing what their job is and doing their job and having the resources to do their job. And what is really disturbing to me is the fact that it took the CCRC as long as it did to refer Andrew Malkinson's case. It had an opportunity years before it did, when it was discovered that there was male DNA on the victim's underclothing, and that opportunity was missed. And it was only thanks to the, frankly, relentless efforts of appeal that brought about that change of mind. But in my view, a proper consideration of this case at a much earlier juncture should have given rise to a conclusion that there was that real possibility.
Yes, James Burley's point was that had the CCRC searched the available databases when his case was first referred to it, they would have found a match between DNA on the victim's vest top with another man whose DNA had already been uploaded to the relevant databases that would have been searchable. And his point is they only really act if you hand such evidence to them on a platter. What they don't do is go off and perform a wider ranging inquiry, even though he says they have the power to do so. Do you think there's force in that?
I absolutely do. And if we're talking about the significance of investigation, the CCRC deploying the powers it already has is critically important because they have a panoply of statutory powers to require for production of documents and evidence. And just as they can be criticised for being slow to refer cases, they can be startlingly reluctant to deploy those powers.
Is the CCRC properly set up, Joanna?
I think as a concept, it's properly set up, yes. I mean, it's staffed by experienced, talented people that, in my view, want to assist, because that's why they've gone into that line of work. I do have a problem with the test. I think the test is slightly woolly. I think that it's slightly subjective. I might look at a case and think that there's a real possibility that the Court of Appeal would be troubled by it. And Max might look at exactly the same case and think that's absolutely fine. And at what stage does that subjective test become too cautious if you're worried about referring too many? But of course, that must be balanced against the fact that I'm afraid vast swathes of people think they've been wrongly convicted. And some of them hold that view very passionately. And that might be because they're right, but it might also be because they're wrong and they either can't accept it or they're trying their luck. So there has to be a filter on the test. It can't be, I think I've been wrongly convicted and I've got the CCRC on board. I think some of the criticism of the CCRC ducks that difficulty because it is really difficult. But it must be better to refer 10 cases where the Court of Appeal say, I disagree with you, but the 11th where they remedy a miscarriage of justice. And so I think it could err slightly more on the side of a conviction being unsafe, being arguable. The addition of real possibility implies a quality above arguable. It ranges from things that are actually possible to erasing certainty. And that range, I think, could be looked at again.
So you think that the threshold may be too low? In other words, that they need to be satisfied of a lower evidential threshold and then pass the problem on to the Court of Appeal? What, as a matter of their discretion or something that they must do in every case where they think it's arguable that it was unsafe?
Well, I think if an experienced lawyer looks at a serious criminal trial and thinks it's arguable that something has gone wrong, then I don't think it's unreasonable that ought to go to the appellate courts.
So part of the problem, Max, is that you're still making a predictive judgment as the CCRC as to what some different body, namely the Court of Appeal, is going to decide. I mean, unless it's going to be said that the CCRC or some other body other than the Court of Appeal will actually have the function of overturning convictions, which would be radical and out of step with the way the basic system works. Anybody who's looking at miscarriages is going to have to predictively form a view, aren't they, on what the Court of Appeal is going to make of a case. It strikes me as quite a difficult judgment to make. You're not just looking at your own independent view of how strong the evidence is. You're asking yourself necessarily what the Court of Appeal is going to make of it.
That's true. A criticism that is often levelled against the CCRC is that in some way it's too fearful or respectful of the Court of Appeal's decision-making. But in my view, necessarily, not every reference made by them is going to be successful. They need to acknowledge that they are fulfilling a really important function and give the Court of Appeal the opportunity to do what the Court of Appeal is there for, which is test the safety of the conviction in light of whatever fresh evidence or arguments have come to light.
So, Joanna, you then, I gather, take a slightly different view from someone like James Burley on the fitness for purpose of the CCRC.
I think they're a precious body. I don't doubt that they're doing a difficult and good job. But I think that the test we could improve on in difficult circumstances.
All right, well, there we must leave it. Thank you very much, Max Hardy and Joanna Hardy-Susskind, for cross-examining with me today.
Thank you, Tom.
Thanks for having us, Tom.
We've reached the end of the podcast, but we'll be back soon and we'd love to know what you'd like us to examine next. Tell us what you're interested in or concerned about in the world of law by tweeting at CrossExaminePod. Remember to follow us wherever you get your podcasts. And if you've got time, we'd love a positive review on Apple Podcasts. It's the best way to spread the word about cross-examination. Meanwhile, I've been Tom Cross, and until next time, goodbye.
Cross-Examination is written and presented by Tom Cross. The producer is Jelena Sofronijevic.